everybody? Here we are taking a look at a monster right here. And the person of Darrell Brooks. I don't even want to call him a person. This is an animal. I don't want to insult an animal. He's definitely a monster. He has made a motion. Well, he's momentarily going to make a motion to the judge, which I think is highly arrogant. He's trying to get her to dismiss this case because there's no plain and fair. I think that is not only a slap in the face.
Calling State of Wisconsin versus Darrell E. Brooks, case number 21C.
What I was saying, I'm sorry, y'all. Not only is that a slap in the face, but did he really think that the judge was really going to end this for him because there was no plaintiff that was in the courtroom and he was going to walk away a free man? And guess what? I don't think that even if, let's hypothetically say, watch this. Let's hypothetically say that the judge did grant him his request of relief from all charges from this case. I can guarantee you that as soon as he walked outside, somebody would have killed him cold blood. I'm telling y'all. I don't think he would have lasted 2 seconds, but that's just my theory. All right, let's get back in.
F1848, may I have the appearances, please?
Morning, Judge Sue. I'm Lindsay Daisy and Zachwood Chow appearing for the state.
Sir, would you please state your name for the record?
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments.
So wait a minute. If he doesn't dispute the facts, isn't that admission to guilt? Right? He's not disputing the facts that they have. So that's another oxymoron. How does he think that he's going to get out of this? This doesn't make any sense. I'm sorry, man. It's just not working.
Right, the record should reflect that the individual known to this court as the defendant, Darrell Brooks, is present in court. He's in custody, but
you know what I like? How every time he suggests that he doesn't go by the name Darrell Brooks, judge comes right in and refers to him as Darrell Brooks. The defendant known as Darrell Brooks. I love it.
Wearing street clothes. He's wearing a suit and tie.
I love it.
And a mask. And good morning once again to everyone.
Not identified by that name or consent to being called that name.
Okay, Darrell.
So noted. All right, Mr. Brooks, do you have
You see how she said Mr. Brooks went right back to it. She ain't dealing with his foolishness. Not
13th
even.
subpoena? As we discussed yesterday, you wanted to call 13 witnesses. I told you you had until this morning to fill out another subpoena and give it to the state so that they could review it.
Yes, I do.
All right, can you hand that to the bailiff, please? I'll just take a look at it quick.
Yeah, we don't want you to approach the bench. We don't want to see shocks on your feet, so you say. Somebody had shocks. And by the way, wait a minute, hold up. And by the way, do you think the jury would have cared if they would have found out that it was shocks? And that was something that he wanted the jury to know. Like, they need to know that I'm wearing a shock. I'm pretty sure they probably was like, good, why don't you start running so you can get shocked? That wasn't moving the needle. So what? Who cared you were wearing shocks? Oh my God. Like that was going to have the jury feel sorry because he was wearing shocks. So what? He should have had shocks on his mouth. All that diarrhea that was coming from his mouth. All right, the judge is reading something frivolous that he made up. Watch this.
Mr. Brooks, I'm reviewing this for completeness.
Uh-huh.
And you have simply put on here, State of Wisconsin plaintiff. That's an entity. What's the name of the person, sir? Well, the date we would fill in. So I'll have it shown to the state.
What's
and they can let me know their position on that.
The state is
Legal
going
basis why that would not be accepted, Your Honor.
because it's frivolous.
You have to have a person named, sir.
Right.
So that they can come and testify. You only have an entity named.
Is it not true that under the Sixth Amendment I have the right to face my accuser?
Here we are, sovereign citizen.
Mr. Brooks, let me hear from the state.
They're going to refute it.
Yes, Your Honor, I agree with the court's assessment. The subpoena does not state a person. The subpoena form specifically indicates that the person requesting the subpoena is to indicate the witness's name and address. Mr. Brooks has simply written the word State of Wisconsin
Right.
plaintiff for the witness name. State of Wisconsin is an entity, it's not a person.
Right.
The state of Wisconsin cannot testify at these proceedings, so the subpoena should be rejected, Your Honor.
See that?
Yeah, Your Honor, on the grounds that every document that was filed in this matter stated that the state of Wisconsin was the plaintiff, which would lead me to believe that the state of Wisconsin is who's bringing the claim against my client.
Okay, school them, Judge.
How could they not be subpoenaed to testify if they're the plaintiff?
You're about to find out.
And under the Sixth Amendment, I have the right to face my accuser. My accuser in this matter is the plaintiff, which is the state of Wisconsin.
Okay.
Attorney Opper also brought up that it didn't have an address on there. None of my subpoenas had addresses, as we went on the record, and that was stated that a lot of the paperwork that I have don't have a lot of the people's addresses on there. And those subpoenas were accepted, so I don't see the difference with this subpoena not being
Okay,
accepted
we're about
for
to
the
find
reasons
out,
that
sir.
Attorney Opper just stated.
Okay. You're about to find out. Here we go. Go ahead, Your Honor.
Mr. Brooks, in relation to that subpoena, based upon my review for completeness, this court would note you have not named a person, you've named an entity.
Strike number one.
And the subpoena will be kept on file as part of the court record, but I'm not going to require the state of Wisconsin to testify in this case because they are an entity and you have not named a person.
Are they not, or are they not the plaintiff, Your Honor?
Here we go.
They are the plaintiff in this case, sir.
And why are they not able to testify, being that
Sir,
they?
you have not named.
He didn't
named
put a
an
name
entity,
on there.
Not a person. People are called to the witness stand to testify. You have had an opportunity to cross-examine every single person who has been called by the state to testify in this trial.
Exactly.
I believe that your Sixth Amendment rights have been complied with.
Absolutely.
Not if I'm not allowed to face my accuser, Your Honor. My accuser in this matter would be the state of Wisconsin.
Darrell.
And
Darrell.
with all
Sir,
due
I believe your
respect,
Sixth Amendment rights in that regard have been complied with.
Exactly. Can we move on?
I'm requesting a written judicial finding of fact and
Denied.
Conclusion of law on this
Denied.
issue
Denied.
for the grounds that I just stated.
See, why don't he? The thing is, if he has a problem with her ruling, why don't he make that argument in the Court of Appeals? Because all this is just holding up the trial. This is delay.
Seen based on the Sixth Amendment
Darrell,
that I'm
I don't
not
know
being
what you're talking
awarded
about.
the chance to face my accuser, which I should be awarded that based on the Sixth Amendment. If I'm not able to face my accuser,
oh my God.
then how can the claim even stand?
How many times she's going to
How can the claim be brought against my client if I'm not able to face the accuser?
All right.
So this case is a criminal case
Right.
in a court of competent jurisdiction in the state of Wisconsin, Waukesha County. This case was initiated initially by the filing of a criminal complaint. Then there was a preliminary hearing where probable cause was found. After that point, there was an information that was filed. And at some point, an amended complaint, perhaps even a second amended complaint, was filed as well, putting you on notice of the charges and the factual basis for those charges, along with the statutes that are alleged to have been violated. I'm not going to explain any further
Right.
why you can't call the state of Wisconsin in the way that you've subpoenaed them or attempted to subpoena them for the reasons I've already
Right.
stated.
There's no
I
name on
understand where you might disagree with the court's ruling, but my ruling stands, and I'm not requiring the plaintiff in this case to
testify.
serve that subpoena in any way for the defects I've already noted.
May I state for the record,
And I'm
Your
also,
Honor,
hold on, I'm also not going to issue a written decision on that. The record speaks for itself.
may I state for the record, Your Honor, that I have not even seen a complaint in this matter.
Oh my God.
And the jurisdiction still has yet.
Darrell, let it go. You're not advancing anything. She's not going to reconsider anything. Everything she said in terms of her ruling stands. How many times is she going to keep telling you, even in the previous part of the trial, if you disagree with my ruling, if there's a conviction, take it up on appeal. Stop
To be
fighting with
proven,
her.
which is another thing that needs to be challenged. There has not been proven that there's subject matter jurisdiction as of yet. There's no verified proof of it.
All right, well, it's obviously verified because where are you right now, Darrell? Let me ask you a question. Where are you? You certainly ain't at a fair or a park somewhere. That's for sure. Okay? Where are you right now? You are in behind bars. I was getting ready to say the pearly gates, but you know that would never happen. You ain't in no damn pearly gates, that's for sure. So my whole thing is, here we go with the subject matter jurisdiction. That is absolutely meritless at its finest. Means nothing.
No verified proof of even a claim, especially if I'm not
Darrell.
allowed to face my accuser.
Darrell.
I don't understand
Is she going to explain to you?
how you can make that judicial decision, Your Honor, when
Take it up in appeal.
it's clear discrepancies in the paperwork of this matter. Like I said, I have yet to see jurisdiction be proven. It has not been proven. I have yet to see a complaint. I have not seen that.
The court has provided you with, I believe it was
Absolutely.
the second amended criminal complaint, along with the information that was provided to you previously and noted on the record. I've already addressed your motion to dismiss previously. I'm not going to revisit that. There's no legal basis requiring me to do that, sir. The plaintiff in this matter has presented witnesses to establish venue. And again, as I've noted previously, it's a criminal case with criminal charges, with a second amended criminal complaint detailing the factual basis upon which these charges are based. We are notice pleading state. And along with the information, you've been made aware of all of the charges and the penalties you face, and the factual basis upon which the state has brought these charges.
Right, which means they have subject matter jurisdiction. So why does he keep going back to that? I don't know if somebody might have given him like some information while he was in jail, because he was there for a year before they actually commenced with the trial. So I don't know if somebody was feeding him like basically disinformation, because it was basically he was spewing it and it worked against him. I don't know if he thought that this was going to advance, he was going to win. I have no clue, but he kept bringing that up and it meant absolutely nothing. But yet he still wants to fight. He's still, even at his own peril. He was already told at one point how hard it is to represent himself, but he still decided to go about it that way. I think if he would have had an actual attorney, well, we all know inevitably he would have went to jail. But if he would have had proper representation, the attorney probably would have been able to cushion the exacerbation that he caused in the light of representing himself. So he just went about everything just stupidly. But hey, it's Darrell Brooks. How can anyone be surprised, right?
We are in the middle of trial. Your objections are noted. We will continue today with the jury trial.
For the record, may I respectfully move for an interlocutory declaratory appeal on this matter?
That's dumb. Why is he asking for an appeal? This is not an appellate court. He doesn't know what he's doing. You don't ask for the appeal. She's a okay. Judge Darrell is a trial judge, not an appellate judge. Okay. So why is he asking for a declaratory interlocutory appeal? I don't understand this. Where's he getting this from?
Your Honor.
Your request is noted for the record. I'm not an appellate court, sir.
Exactly.
For the record.
Wait a minute, did y'all hear what she just said? I'm not an appellate court. So why is he saying this?
May I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction
Your request is denied.
based on what law or fact, Your
Here we
Honor?
go with this again.
I've previously addressed the issue,
Yes.
sir, based on law of the case.
Are you making a judicial
Darrell, shut
determination
up. It's
that
not
I'm
working.
awarded my Sixth Amendment right to face my accuser.
I'm not making any
How many
such
times is she
determination.
gonna tell you?
All right.
What
You
law
can't
or
win.
We're going to turn to the district attorney's office.
Darrell, you cannot win. You are in a no-win situation. Stop fighting. This is an uphill battle that you will not win. It's not going to happen. I don't care what you do. It's not going to work.
Have a witness available.
Yes, we're ready to proceed, Your Honor.
All right, our jurors here. All right, the jurors will be brought out, sir.
Now, let's see how he acts in front of the jury.
With all due respect for the record, you're avoiding my questions.
Oh my God.
Mr. Brooks, I've addressed the issues that need to be addressed this morning. I've
Nah,
also
you're avoiding being smart because you're being a dumb. I can't say it. You know what I meant, y'all.
addressed the same issues probably every day we've been in court. I know you may be dissatisfied with the response that I'm
Absolutely.
providing to you, but my responses stand.
It's not a dissatisfaction, Your Honor. It's a lack of understanding, which I don't have.
Well, why did you fire counsel? I mean, I don't know how many times we gonna say that. Listen, ignorance is not a defense. Not at all. That's not a defense. That's not gonna work. What else
I
you got?
don't even understand the true nature and cause of the
Now
charges.
you know that's bull.
And
Mr.
without,
Brooks, you've been made aware of them multiple
Right.
times.
I do not understand
I-
them, is what I'm
It
saying.
doesn't matter that you don't understand, because that can be debunked by you getting rid of prior counsel to represent yourself. So what do you understand a little bit, and then you understand what you want to hear? Remember, y'all, let me ask y'all a question. Do y'all remember when he actually called one of the witnesses, right? It was one of his witnesses. That was the girl. I can't remember her name, but he was admonished by the judge to stop badgering, eye rolling, lip pokering this witness. All right. When he had her on the stand, first of all, he was so nasty to her. That was. Do y'all remember him saying, "So you recall what you want to recall, but then you're not recall what you," and that's what they see. See what I'm saying? So it's almost the same thing what he's doing. It's like he understands, and then when the tough gets going, now I don't understand the proceedings. I don't understand. I don't. You see what I'm saying? It's the same thing. This dude is a joke, and you don't think the judge can see right through this dummy, this clown? Really? And do you think the appellate court, okay, is going to review this and rule in his favor? I don't think so. Judge Darrell did everything strategically by the book and got everything on that record of what he did or said, even when he took his shirt off.
Once again, if you don't understand anything, to seek the advice of an attorney.
But he fired them, Judge Darrell. Judge Darrell, he fired his attorney. He fired them. But now he doesn't understand. Judge Darrell, didn't you tell him before he decided to do something stupid like that by getting rid of... Didn't you tell him the pitfalls? Excuse me, the pitfalls? Didn't you tell him what was going to happen in terms of the difficulty of representing oneself as a pro se defendant? Didn't you enlighten him on that? Didn't you advise him on that? Didn't you admonish him? Didn't you warn him? Didn't you ill-advise him really of doing that? So whose fault is it? This is the number one question we got to ask. Whose fault is it relative to his lack of understanding. Whose fault is that? We used to sing a song in church. Said, nobody's fault but mine. In other words, if I go to hell, that's nobody's fault but mine. And so what am I saying? This man went to hell in a handbasket. And guess whose fault it is? Darrell Brooks. Let's keep this rolling.
I cannot give you legal advice.
I'm not asking for that.
Yes, you are. Yes, you are. Yes, you are.
I'm really asking why are my constitutional rights being
Oh,
prejudiced?
please. Please.
It states under the Sixth Amendment that I have the
Sir,
right.
First of all, you shouldn't even be quoting the Sixth Amendment, the Constitution. You should not be quoting the Constitution, given the fact that you are a sovereign citizen. So that gets shut down right there. Keep it going.
may address this.
You don't want none of me.
Okay? We're not going to have any
Right.
further argument on this.
This is
topic.
circular.
All right,
You
your
don't
Sixth
know.
Amendment rights are being honored
Uh-oh.
no
You gonna say
differently
something
than
else?
any other defendant that has appeared in
You
my
gonna
court.
move in with
Have
something else?
any other defendant not been awarded the opportunity to face their accuser?
You are facing your accuser, sir. Every single witness who's been on this stand, you have
Exactly.
cross-examined.
None
Exactly.
of those witnesses are making a claim.
Oh.
None of those witnesses are the plaintiff. None of those witnesses are identified as the injured party.
Darrell,
An
you're
injured
digging-
party has to make the claim. Your
Darrell,
Honor.
you're
A
digging
It's
living-
hole.
my opinion that your belief as it relates to that is
mistaken.
mistaken. It's not a lawful argument.
Right, so
and
shut up.
It's frivolous. I've direct your attention once again to the Beneby decision.
He ain't gonna listen, Judge.
Is that
Judge,
not-
you're wasting your time going over case law. He's not gonna listen to that. You know why? Because it's not going in his favor. Anything that doesn't go in the favor of Darrell Brooks, he's going to be against it. Even when he knows he's wrong, he's still going to fight. That's just like when he was found guilty relative to those verdicts of the jurors. Then he starts sparring with the judge when it came to sentencing. In other words, he had already lost, but he's still fighting in the midst of his own peril. Which makes absolutely no sense. I don't get it.
federal case, United
See, now
States.
he's gonna
You're
challenge
asking me for legal advice. I'm not going to provide that
I'm
to you.
not.
sir.
Well, see, that's the thing, Judge Darrell. You should never even mention the Beneby, because he's gonna find another way to debate, and now we're going down a tangent. You can't give him any rope unless, well, basically she did, and he hung himself, which was a good thing.
Asking what kind of case it was. Was it federal Supreme
Yes, it's
Court
a Seventh
case?
Circuit Court of Appeals case. We're in the Seventh Circuit, sir.
Exactly.
But you just stated that you're not
Oh, my-
a court of appeals. So, but you're citing
Oh, my
a
God.
court of
No, but
appeals
Court of
case.
Appeals case law applies to this court, sir.
Exactly.
Bound by legal precedent from the various courts
See how dumb he
that are
is?
above me.
See, he don't even know that.
And
Shut up, man. It's over.
I'm not able to face my accuser.
Darrell, stop saying that crap.
Constitutional right
Sir,
to
I'm not
be
going to
able-
explain the law to you.
She-
I've made my decision. It stands.
Leave it
I'm not
alone.
arguing that part of it.
Leave it
I'm just
alone.
merely stating for
Bro,
the record.
leave it alone.
Okay, thank you.
I'm merely stating for the record.
Shut
that
up.
she
Leave it
awarded my
alone. You're
6
not
right
going to
face my
win.
Your
accuser.
objection is noted, sir, once again. We'll continue this morning. Thank you.
None of the witnesses
Oh my God.
that testify are the accuser. None of the witnesses that testify
Darrell, you're not
the injured
going to
party,
win.
which a claim has to be made by a living, breathing
That's
human being.
That's BS.
Sir, I
Which
think you're
have not.
confusing civil law with criminal law.
Right.
That's what
No,
I'm
I'm
saying.
confusing.
Yes, you're
I'm
confusing.
not
Yes, you said it
confusing
right.
Any law.
You said it right the first time.
Constitution
You're definitely
says
confusing.
that I have the right to face my accuser.
How many times is he going to repeat
And
that?
under the Sixth Amendment, I'm not being awarded.
Make that argument with the Court of Appeals, and I bet you they're going to laugh at you. Laugh you right back to the jail.
Constitutional
Stupid.
right. I think that definitely needs to be on record, and that definitely is the issue that needs
Your
to be
objection
raised.
is noted, sir.
Right.
I believe
Can we
I've erred
continue?
in that regard. You can raise that issue on appeal if you
Right.
are convicted.
May I put Your Honor on notice that I intend to appeal that decision?
So, go right ahead. They're going to laugh
Your
at you.
statement's noted for the record.
All right, so can you shut up now? Can we bring the jurors out? Can you shut up? It's not going your way. It's not going to happen for you.
Is that a judicial determination?
Oh, here we go.
I'll be able to
Here
face
we
my
go.
accuser, Your Honor.
Here we
I
go.
have not made any such determination, sir.
Will you be making a judicial determination?
Sir, I have not made
This man
any kind of determination
is
that
a
your Sixth
mental
Amendment rights have been
retarded.
violated. On the contrary, I believe this court has
Sickening.
honored those rights.
Even with me
You know
not
what?
being able to.
Hold up. Let me say this. Is it now? If I'm not mistaken, I was told that it was the judge's discretion whether or not he would be able to represent himself or not. I think the judge should have declined doing that because he was kind of disruptive even in the preliminary of all of this. When he wanted to get rid of counsel, he was kind of going back and forth with the judge. I think the judge should have caught on. All right, in other words, if he's acting like this during the preliminary phase, then oh my God, what is going to happen at trial? It's going to be a mess. So I don't think that she should have, and even given the fact, I mean, going back to him saying he don't understand the proceedings, all of this, looking back in hindsight, I just think that she probably should not have allowed him. I know that it's his right to represent himself, but I don't think, well, obviously it didn't turn out to be a good decision. And it basically exacerbated the whole thing for Darrell Brooks, which is a good thing for the city of Waukesha and that whole community. Let's get back
Face
into
my
this.
accuser, which is the
He's
state of
still
Wisconsin.
talking about the same thing. It's circular. She keeps on debunking him, and he keeps on fighting. For what? For what? Why do you keep going back to the same thing? Just like when he was questioning witnesses, y'all, asking them, have you seen the plaintiff in the courtroom? Have you ever heard of the plaintiff? And it kept being objected by the state, and the judge kept sustaining those objections ad nauseum. So my question is, why did he keep doing stuff that wasn't working like he's doing now? Going back to facing my accuser. She just explained to him, watch this, ad nauseum. But yet he keeps going back, trying to fight, trying to stand in the midst of a lack of foundation, baseless, meritless.
It is noted, sir.
Is
It's
that a
noted for the
judicial?
record. I've already addressed it.
Is that a judicial
my God.
determination?
Oh my God.
Sir, the record speaks for itself.
Is that a judicial determination?
Are you mentally retarded?
All right.
Give me a hell
The
yeah.
chairs are coming out. All rise, please.
Is your hairline missing? Hell yeah. Was your mother complicit in that effort to try to discredit Erica's credibility? Hell yeah. See, I can get him on a whole lot of
Are you
stuff.
going to answer that, Your Honor? Or is that a tacit agreement?
Was that you behind the Ford Escape down? Or was that somebody else?
I'm not going to answer that further. I've answered it multiple times.
Is it a tacit
Multiple
agreement?
times. There's no such thing as
It
a
is not.
tacket.
Then I should be awarded my Sixth Amendment
Absolutely
right to face my
not.
accuser.
Absolutely not.
Or judicial determination.
Absolutely
The record should reflect that the jurors are coming in for the morning. Good
Right.
morning, ladies and gentlemen.
The record should also reflect that.
Shut up. The
received
record
no
should
answer
reflect
to
that you are
question
a
from-
murderer. The record should reflect that you are a murderer. I think they already knew that by now.
And good morning to the remaining jurors who are
Given the overwhelming evidence, I want to find a different part of this trial that I want to refer you to that I think is interesting. Hold on, y'all. Okay, so I want you to see this part of it. Now, notice he starts off with the word how. All right, I want y'all to copy and paste. First of all, copy, and then we're going to paste that same word again. Watch this.
How are some of these answers allowed to pass when they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question. I'm not sure what you're asking me.
What I'm asking is,
Come on, dummy. Get it
reading
out.
from the report
Come on, dummy.
that the people on the stand are giving,
Come on,
the
dummy.
report that they gave to law enforcement.
Come on, dummy.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the answer to that is yes. If you're asking me how you do that, I'm not going to answer that.
I didn't ask how.
Up. Didn't he start off by saying how? Wait a minute, hold up. That's why I told y'all to copy and paste the word how. So he just lied and said that he didn't ask how. He's not even. Look, see, you caught yourself.
To be blunt, which I've been
Yeah.
since the beginning of this trial, obviously.
Okay. Ew.
I see the whole strategy
Ew,
here
look
by
at
the
that nasty,
prosecution.
look at that nasty smile. Ugh. God, that's ew. Look at that.
I see right through it.
That Satan
Don't have
smiling.
any cross-examination,
Ooh, look at the evil.
mainly because you've already.
It's like even when if you notice when he smiles, he still looks evil. Usually when somebody smiles, it's like a joyous, but when he smiles, it's evil.
School.
Let's go back to that smile. Wait a minute.
Ow.
Let's see.
I just.
Wait a minute. Hold up. Let me see.
To be blunt, which I've been since the beginning of this trial, obviously.
Ew, look at that.
I see the whole strategy
Look.
here by the prosecutor.
Doesn't that look evil?
I see right
It just
through
looks evil.
it. Don't have any cross-examination,
Oh my God.
mainly because you've already schooled
That's speculation.
the people.
How do you know that?
On how to answer certain things.
How you know they school?
Well, that is completely speculative on
Exactly.
your part without any basis in law or
It's
fact.
obvious.
Sir, you could ask questions that establish that. You can ask them if they've met with anyone. You haven't done that. So for you to
Exactly.
say that right now
It's
is without
speculative.
basis. If you want to,
It's clear.
if you are looking to elicit what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that. But that requires you to call certain witnesses. I'm not going to give you any
I don't
more
think I have
legal
to- I don't
advice
think I have
further
to-
than that.
I don't think I have to
So
call any other witnesses. That's
if
not
you're
on the
asking me to
stand.
strike their testimony based
I
on your
didn't say
perceived,
anything
then that's
about that.
Well, what are you
all right.
saying?
Then I'm going to bring the jury back out. You're going to call your next witness. So I'm
So
not
you-
hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach?
How do you, first of all, how does he, how can,
Assuming that-
wait a minute. Why would he say that? How are they allowed to coach? Was he there? This is speculative, what he's saying. Like, how can you allege that?
I spoke to them and coached them.
That's just like they're not allowed to see.
It's
Watch
obvious.
this. Watch this. It's obvious that you killed these people, but they can't say that you actually did it until those verdicts come in. So they have to be by the book, because otherwise that would be considered speculative, even though they know you did it. But in this case, he's trying to say it's obvious they were coached. You don't know that. You don't know that in fact.
I'm not stupid.
That's a lie. Serving 7 million years in jail? This sounds idiotic to me.
Well, I disagree
Watch this. You could have fooled me trying to suggest that you ain't stupid.
with that, sir. Again, you could ask
All of a
questions to
sudden-
lay a foundation
All of a sudden, the
with
state
these
don't got.
witnesses.
All of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this
And
is
not-
argument.
Come on, man.
This is argument on your part,
I
sir.
see
It
through
is
it.
pure
I just want-
commentary
I just
at
want
this
that on
point.
Pure BS. That's what it is.
I see through it.
Okay,
And your
cool.
Nice try,
see-through
but I see through it.
has absolutely no basis in law.
Yeah, I know that's what's being done.
You could
Come on, man.
ask
It don't
these
matter.
questions. You could
Come on,
ask
man.
these
Got the right
witnesses
one.
certain questions, and
I'm
you're
far,
not.
far from an idiot.
That's totally untrue, which has been proven time after time.
Your witnesses, sir.
Far
You
from it.
believe.
So I'm gonna start asking every witness up here that they see.
Wait a minute. He's far from an idiot, but then he asks one of the witnesses that he subpoenaed, did she know what she was subpoenaed for and what the case was for? Isn't that idiotic? Wouldn't she know why she's there if she was subpoenaed to be there? And then you're going to suggest that you're far from an idiot? What?
Just to mysteriously now not have any cross for it, have they been coached to answer the way they answer? Because
Well, you can't
I
ask
find-
that, but
I
you can
find
ask
it
them
very
if they've
funny.
met with anyone ahead of
I
their
find it
testimony
very
here
funny.
today,
I find
which
it
you've
very
done
funny.
with other witnesses.
I find it very funny that
Darrell, would you
these
shut
are
up,
their
man?
reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Russ,
I I saw
It's
them
an
reach
attempt
for
by
something.
you
Oh,
to
I don't,
delay these
I don't recall
proceedings.
what they had on.
That's all he's doing is delaying. That's all this is. Delay. See? You know it's delay. Because he's already talking about the state was releasing people to try to hurry up and rush through it. So what is he trying to do? He's trying to throttle. Speaking of the throttle body of the vehicle, what do you think he's doing right now? He's trying to throttle the proceedings.
There's no purpose for you saying this right now.
Come on.
What they had on. I find that
All
very.
right, I'm having the jury brought out. I'm instructing you to
Come on,
avoid
man.
the commentary when the jury comes out, or you will
I didn't
forfeit
say-
your right to be
I didn't
present.
say nothing. You.
All right, shut up. Let the state talk.
Take up potential as to a witness by the name of Abel Lescano. He has prior criminal history.
Thank you.
So as long as the jury's out, we should probably.
All right, I want
discuss
to
that.
refer you
I
to
would
another
like
part
to
of the case
provide
that I thought was
defendant.
interesting. Hold on. Darrell, we're back in looking at the back part of the look. He's shaking his head. You can already tell that there's going to be a problem. He's about to go off. He's moving his head. I'm getting a look at the rear of Darrell Brooks, aka Monster. He really looks pissed off. You could tell. I mean, you can't see his face, but the way he's sitting, the posturing, he is pissed. He's not a happy camper. Well, I wouldn't either if I had to serve 7,000 years in jail. Nothing happy about that. So we are awaiting Judge Darrell to come in so we can resume the proceedings. And we're waiting for her. Here we go. She's about to approach the stand or the bench. Here we go.
All right, we are back on the record. Mr. Brooks, I was able to inquire. I've been told it would take maybe 15 minutes, but I'd like you to go to your cell to get
Go to your cell.
whatever that list is that you have so that I can adequately advise the jury, potential jurors, about any witnesses who may be called in this case. I don't designate when I say if it's the state or the defendant, but you told me you have that, so I'm going to give you that opportunity. In the meantime, I'm going to print off the state's witness list
I don't need it.
and give them to the state so that you can cross out any individuals who are already listed in question 89.
We have that already, and we just started doing that.
All right. And then what I plan on doing is once I finish with all of the questions and the follow-up of this group, I will bring, and then we'll discuss if there are any additional strikes for cause. Okay? Once I get through that, I'm going to bring in all of the jurors. So I'm going to do an audible. We'll have to, I know the press has been here. You'll probably have to be in one back row together. There is the press.
And by the way, if I can say something, here's another. I'll note this. This is another reason why not to get into criminal mischief, because everything is public. You listen. You'll be on court TV. You know, just like when Darrell tried to say one of the jurors had wrote a Reddit post, you know, about what was going that had intimate knowledge. Listen, everything was live streamed. Everybody had intimate knowledge about what was going on. You know what I'm saying? So that's what I'm saying. They got court TV there. Everything is public. And so it to me, it's just not worth. It's not worth getting in trouble.
The jury assembly room, if there's not enough room there.
Let's put it this way. I would have never known who Darrell Brooks was, okay, if he had not committed that heinous crime. How do I know it? Because of court TV, because of the publicity of all of that.
And we'll just figure it out from there. But I'm not closing the courtroom by any stretch of the imagination, but I need to, that's a long witness list.
And I don't even know, I never even knew Judge Darrell. But I'm glad I do now. I love her. I just think that she shouldn't have put up with a lot of his crap.
Need to make sure none of these jurors know any of these individuals, either personally or by reputation, work with any of them. but we should be able to do that, still maintain some
Let's see if we can
room for
fast forward a little
victims,
bit
some
to get into Darrell
Any
Brooks,
questions?
what he has to say.
remaining
Uh-oh,
from
here we go.
yesterday and today brought in the courtroom. All of them have numbers, and you'll be able to do follow-up that is appropriate. Now, you also mentioned previously when I referenced going back to your cell to get the list.
Your cubicle.
I'm giving you that opportunity. You asked me to do that.
I did not ask you to do that.
Uh-oh. Here we go.
The question was, where was the list at?
That's true. So you said the list was in your cell. I'm advising you that I'll give you the opportunity
I
to
don't
go.
want to do that.
Can I finish? I'm advising you that you are being given the opportunity, if you so choose, to go back to your cell to obtain the list of witnesses that you have been working on. Further advising you that if you choose not to do that, your one option would be to verbally tell the court any additional names to what you've already provided.
Right.
Write those down for the court, so that either tell me now or write them down so that I can include them in the list of names I'm providing to the jurors.
So how am I supposed to do that without the list in front of me?
Go to your cell and get it.
The list that you have in your cell?
How am I supposed to do that without
I'm
the list?
telling you, I'm
Go to
giving you
your
the
cell.
opportunity to go get
I'm
that.
not
So,
gonna go do that.
Mr. Brooks, I'm not gonna play games with you.
And
I'm
not-
giving you an
I'm not gonna-
opportunity.
and I told you
You
that I'm
either
not
go to
gonna
your
do that.
cell and
You
get
said
the
I have the
list or
opportunity
not.
Oh
to
my
do that.
God.
All
You
right.
said I have the opportunity.
I'm not
going
gonna
to
demand
do
that you do it, but you have to understand, sir, that if you
I
choose
don't
not to
understand.
do
I
that,
don't understand. I don't understand.
all right,
I
Mr.
made
Brooks.
that clear.
Oh my God.
I don't know how
Claim
many
to not
times for the
understand, and
record.
that's been made very
No,
clear
I don't
here, sir.
understand. You're not going to get me to consent to something that I don't consent to or agree to. I do
No.
not
All right.
understand. Just
Mr.
like I
Brooks,
don't
we're gonna
understand
take
the
a
nature
Get him
recess
out.
so that
Get
the
about-
court can
It's
get this
the Google.
information
exactly like I've
from
been
the
telling you
state.
from the beginning.
Okay, he's continuing with his disruptive behavior. It is his choice to do that. Mr. Brooks, you are hereby warned. Once again, if you continue with that, you will be removed from the courtroom.
Remove me. Remove me.
Requesting to go to the other
Remove
courtroom?
me. I told you that before I even
Forfeiture.
came over here.
Sir, are you requesting to
I
go?
told you that before I even came over here.
Mr. Brooks, are you
That
requesting?
It was pointless for me to come over here. You can smile all you want and think
Sir,
it's funny. I don't take this as a
preference-
joke. I don't take this as a game.
My preference is for you to be
You
here.
expect me to answer all these questions that you have for me, Your Honor, but you have yet to answer one question that I've asked you.
All right, get him
You have
out.
yet to verify
Remove him.
anything
You can take him back to the
Get him
other
outta here.
room that has been disruptive.
That would have been very. I would have loved to see. I would have loved to see him being gagged. I think she probably didn't do that because he's. I guess because he's black and most of them are all white and he killed white people. So I guess she didn't want to give him a reason or any type of leverage. Well, I'm black and they gagged me. I don't know if she did it for that reason or not. But hey, what the hell? He needed to be gagged.
I have a question to make an offer for my people.
Thank you, ladies and gentlemen. We'll have to clear the
I
courtroom.
don't agree to a stop and I move this court for a motion to dismiss.
All right, we were back in. Here's Mr. Brooks rambling about integrity of all words. Man, I'm surprised he even used that word, integrity.
Call
Really?
yourself a judge as much as bias you could put up in here. Don't even tell the jury the truth. Got no integrity whatsoever.
Did he just say integrity? Oh my God. This is unbelievable.
None.
You ain't got no integrity.
Thank you,
Been
everyone.
lying the whole time talking about you don't know who that name is, you don't go by that name. What kind of integrity is that? Come on, man.
Be seated.
Oh, look at him. Notice he's not standing. I mean, he's not sitting. She told everybody to be seated. Now you already know there's a problem.
I would like an update on whether Mr. Brooks filled out a subpoena for Dawn Woods and provided that to the state. Has that been done?
No, we haven't received anything, Your Honor, and obviously she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary. We had subpoenaed her, and she was under a state subpoena. So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If
So
I want her to be here, she gonna be here.
See, y'all see the control he had over his mom? That's probably why she bailed him out of jail, because he told her to. She just as dumb as they come and did it like an idiot. Don't let me get started on her.
I agree with
So
the
just
state
know
that
that.
she could certainly appear.
It ain't even got to be no arrangement. All I got to say is come. She gonna come.
Well, now you are in the confines of a prison, which means you have no more control anymore. So you can get rid of all that arrogance, man.
That's simple.
Trust me.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you to have her here at 9
We said
a.m.
all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you?
And so you had integrity in that interrogation room the entire time? Show me the integrity there. So if the court didn't have it, let's say the court didn't have integrity, then how can the kettle call the pot black? That's what I like to know.
You even call yourself a
Mr.
judge?
Brooks, I need to make a record of some
I need to
things.
make a record too.
You don't
When
need
am
to-
I gonna get the chance to do that?
All right, I need to make a record. He's being removed to the other
Yeah,
courtroom.
remove him.
He is yelling at me. He's not going to let me make a statement
Remove
or
him.
make the record that I need to make.
Remove this trash. Let's go to another part of the trial.